Sean, NYC 88, asked the following question, in part: Is Section 1983 suits the only option for federal actions against government officials, whether state or federal, for police misconduct, judicial misconduct, or prosecutorial misconduct? I get the question. I get the concern. I really do. 30 years ago this month, I started practicing law, and I remember having those same questions. And that's what we're going to talk about today. So let's get started. So we're going to look at 6 statutes that plaintiffs can sue under: 42 U.S.C. 1981, 42 U.S.C. 1983, 42 U.S.C. 1985, a Bivens action, the Federal Torts Claim Act, and the State Torts Claim Act. And for each, we're going to discuss the elements that must be proven in order for a plaintiff to succeed in that claim. We're going to identify defendants who can be sued under each claim, and we're going to look at the courts in which the claims are filed for each. Of course, there are other statutes, but for the purposes of this video, we're going to look at these 6. 42 U.S.C. 1981 guarantees United States citizens the right to make and enforce contracts. It prohibits discrimination against citizens based on their race. So let's look at the elements. 1, plaintiff must show that he or she was subjected to discrimination based on his or her race or ethnicity. 2, that the discrimination was related to the making or enforcement of a contract. 3, that plaintiff had a right under the contract that was denied due to the discrimination. And 4, plaintiff must present proof of disparate treatment, that he or she was treated differently than similarly situated individuals of a different race. So let's look at who the defendants could be. All private employers, including individuals, for example, supervisors, and labor organizations, can be sued under 1981. It does not apply to federal, state, or local government employers. Or courts can the individual or individuals be sued in. Section 1981 claims fall under federal law, 42 U.S.C. 1981, meaning they are heard in federal courts. However, they can be filed in state court. In that event, defendant is likely to motion its removal to federal court. 42 U.S.C. 1983 protects individuals' right to sue state and local government officials for violating their rights guaranteed by the United States Constitution or federal law. So let's look at the elements. 1, the litigant must show that the defendant acted under color of state law and that the defendant's actions deprive the plaintiff of rights, privileges, or immunities secured by the United States Constitution and federal laws. So let's look at the defendants, who they could be. State and local government officials and employees could be the defendants, including police officers, jailers, prison guards, election officials, social services personnel, school district employees, and other government actions. We're not finished. Private actors, individuals or entities who are not government employees can be sued if they were acting under the color of state law when the alleged violation occurred, and municipalities and local governments. A municipality can be sued under Section 1983, but not the state or federal government, as they are not considered persons for the purposes of 1983. And what court or courts can these defendants be sued in? Section 1983 claims are typically filed in federal courts as they involve violations of federal rights. However, state courts also have concurrent jurisdiction over these claims. And plaintiff, should you file your 1983 claim in state court, just be prepared for the defendant to file a motion to remove the lawsuit to federal court. 42 U.S.C. 1985 is a civil rights law. It addresses conspiracies to interfere with civil rights. For example, actions to obstruct injustice, to prevent voting, or to deprive individuals of rights or privileges guaranteed by the Constitution. So let's look at the elements. One, there must be evidence of a conspiracy between two or more people. Two, there must be an intent to deprive someone of equal protection or privileges. And three, there must be an action in furtherance of the conspiracy that results in injury or deprivation of rights. So, who could the defendants be? The defendants includes two or more individuals who conspire to deprive someone of their civil rights or who participate in such a conspiracy. So let's look at the court or courts. Federal district courts have original jurisdiction over claims arising under 42 U.S.C. 1985. As well, state courts have concurrent jurisdiction over 1985 claims. Named after the Supreme Court case Bivens versus six unknown named agents, Bivens allows individuals to sue federal officials for damages when their constitutional rights have been violated. So let's look at the elements of Bivens. One, the plaintiff must show that the defendant or defendants were federal employees or their agents. Two, that the defendant or defendants acted or purported to act in the performance of official duties under any federal law. Three, that the defendant or defendant's acts or failures to act deprive plaintiff of a particular constitutional right. And four, that the defendant or defendant's acts or failures to act cause plaintiff damages or injury. And who are the defendants here? In a Bivens action, the defendants are federal officers or agents acting under the color of federal authority. The action is brought against them in their individual capacity, not against the United States. And which court is this action filed in? District courts have jurisdiction over Bivens causes of action under 28 U.S.C. 1331. They must be filed in federal court, not state court. The Federal Tort Claims Act, or FTCA, is a federal law that allows individuals to sue the United States government for damages caused by the negligent or wrongful actions of its employees. So let's look at the elements. The plaintiff must demonstrate that he or she was injured or their property was damaged. 2, that a federal employee acting within the scope of his or her duties caused the injury or damage. 3, that the employee acted negligently or wrongfully. And 4, that the employee's actions caused the injury or damage. Now, who could the defendants be? The United States is the defendant. The individual federal employee whose actions cause the injury is not the defendant unless the employee was acting outside the scope of their employment. And what court has jurisdiction? Federal district courts have exclusive jurisdiction over cases brought under the Federal Tort Claims Act. A state tort claims act allows individuals to sue a state government for damages caused by its employees' negligent or wrongful actions. This effectively waives the state's sovereign immunity. So let's look at the elements. 1, the claimants must show that the government entity or employee owed them a duty of care. 2, the plaintiff must show that the government entity or employee breached that duty by acting negligently or wrongfully. 3, the plaintiff must demonstrate that the breach of duty was the direct cause of their injury or damage. And 4, the claimant must show that they suffered actual harm or injury as a result of the breach. Who are the defendants? The defendant is generally the state itself, not the individual employee who committed the tort. And the court? State tort claims, which are civil lawsuits alleging harm caused by another party, are typically filed in state general jurisdiction courts, which include district and circuit courts. Now, some of you might be saying, well, my complaint does not fit into any of these options or categories. How do I know who to sue, what court to file in, and what elements do I need to prove? Well, I'm glad you asked that question. The most effective way is to read case law. And there are numerous free legal libraries out there where individuals can get access to case law. One I uploaded some time ago is called the Case Law, and I'll leave that link in the description page of the video. You could even Google cases. So here are three things you can consider as you are reading case law. One, what were the defendant's actions? What damages, injuries did the plaintiff sustain as a result of the defendant's actions? Two, at the time of the event giving rise to the lawsuit, who were the defendants? Their names, the defendant's employer, the defendant's job title, and job description, because this will assist the plaintiff in finding a case that mirrors his or her claims. And this will help the plaintiff to identify the cause of action and the elements that the plaintiff needs to set forth in the complaint. It will also assist the plaintiff in identifying who to sue and what court to file the complaint in. Make sense? I trust this has been helpful to you. And I didn't do it earlier, but I want to give a shout out to Sean NYC 88 for making this happen. I'm Advocate Lucinda, and we will see you next time. Take care.